Swayam Prabha. Digital India. Educated India.
Hello once again students. Today we will try to continue our understanding of ancient Bhartiya jurisprudence. As we all know that we had our own jurisprudence in the distant past. In the last lecture we had started our discussion on ancient Bhartiya jurisprudence. Now we will continue that discussion with another great philosopher of that times, of ancient times. His name was Yajnavalkya. What was his theory? What was his contribution to the field of jurisprudence? That we will try to see. In this lecture, we will try to know about Yajnavalkya and what he wrote, what he tried to convey the message in the Dharma Shastra, and what were the sources of Dharma, and then we will move on to look at the position of sovereign in the disputes. Further, we will also see that what was the Dharma of kings or the sovereigns. We will also look at the issues relating to the kingdom, the state and the role of Dharma. Then we will look at what Yajnavalkya said about the role of Brahmans, and then we will move on to see that what was the Dharma for marriage. Further, we will also see what was the importance of evidence, and in evidence what was the meaning of ordeal. Finally, we will also look at some rules on partition and inheritance. So, be prepared. We are going to have an exciting time knowing about Yajnavalkya's contribution in the ancient Bhartiya jurisprudence. Let us try to understand little bit about that great sage Yajnavalkya and what his contribution was, that he transmitted his teachings to his disciples and those disciples further transmitted. So, that is how we have now have the written copy of Dharma Shastra, which was claimed to have been written by the Yajnavalkya. So, when did he come to the light? It was very old time. In the Satpat Brahman of the Shukla Yajurved. Shukla Yajurved is one of the ancient Vedas. There are 4 Vedas, and in Yajurved there is another branch of Yajurved which is Shukla Yajurved, and in the Shatpat Brahman of that Yajnavalkya comes to light. There his name is mentioned. Then it means that it is the post Vedic period, because Vedic period was one period and thereafter post Vedic period was the period of Brahmans. So, Shatpat Brahman, that was written, and in Shatpat Brahman his name comes to light. Satpat Brahman apart, in Shukla Yajurved, the Shukla Yajurved contains the most celebrated Upanishads, and amongst the different Upanishads, Brihadaranyaka Upanishad. So, these things, why I wanted to tell you that you might have only understood that these Vedas have only religious meaning, but there are certain portions of Vedas and Brahmans where you will find some rules also written down and some names who greatly contributed to the knowledge system to the Bhartiya jurisprudence. Now, what is the meaning of Shastra? Shastra means both a scientific discipline and it has presentations of that science in textual form. So, that is the Shastra. We say Nyaya Shastra, we say Dharma Shastra. Shastra is the whole treatise, Shastra is Rasayan Shastra, so chemistry. So, it is a treatise on the whole chemical reactions. Likewise, this is a Shastra means a scientific discipline. Something interesting about that sage was that he was not only a sage who you might have thought that he was a brahmachari. No, he was a grihasthashram and he had married a woman, and that woman was also a celebrated woman of that time. Her name was Maitreyi. She was one of the great philosophers of those times in a kingdom which was called Videha kingdom. You might have heard about goddess Sita ji, and Sita ji's father was Lord Janak, and Lord Janak's kingdom was the kingdom of Videha. Now, in that kingdom, do you know where that kingdom might have been there? That kingdom was nearby India Nepal border of today's times. So, that place you might have heard about Janakpur in Nepal. Now, that place was the place of Raja, the King Janak, and his name, another name of King Janak was Videha also. Now, in that kingdom, Maitreyi was there and Yajnavalkya was also there. So, that was the place where these two people, they were debating, discussing and further trying to propagate their understandings of the rules for human civilization. Yajnavalkya, in short, I will call it Yava. Yava means Yajnavalkya. So, in short, it will be very difficult always to say Yajnavalkya. So, I will say Yava. Yava is the most well known and most commented on the legal text of ancient Bhartiya jurisprudence after Manu Smriti. So, you might have heard about the importance of Mitakshara in our times. Our whole family law has two types of legal basis. So, one is Mitakshara, and that Mitakshara part, who wrote it? Vigyaneswar wrote Mitakshara, and that was written in 12th century. But you know what? That the basis of Yava's Dharma Shastra. So, the basis of Vigyaneswar Mitakshara was Yava's Dharma Shastra. Vigyaneswar wrote Dharma Shastra. Vigyaneswar wrote Mitakshara in 12th century, but that, how did he write it in 12th century? He wrote it, the basis of that text was Yava's Dharma Shastra. So, what is that? What kind of text was that? Was it an oral instruction given to his students? Yes, it was the oral instruction which was given to a group of sages who asked him to teach them all the laws, all the dharmas. So, dharmas meant the rules which are right rules, the rules which were just rules, and therefore, that was called dharma. The text of Yava Dharma Shastra that appeared after almost a millennium after Yajnavalkya's death, around 4th to 5th century AD during the Gupta Empire. You might have heard about the empires of the ancient Bharat. In ancient Bharat, we had Maurya kingdom and the Gupta kingdom. Now, it is told by the researchers that the new version or the written version of Dharma Shastra of Yajnavalkya that appeared for the first time in the 4th or 5th century AD. So, you see that in the last 1500 years at least, now people started to discuss about this text written by Yajnavalkya. Now, we will try to understand little bit about his contribution to jurisprudence. How did he contribute? He wrote or he transmitted the whole wealth of knowledge in the form of what was later named as Dharma Shastra. So, what was that? In the Dharma Shastra, prominence was given to law and legal procedure. Not only substantive law, but procedural law was also given due importance. The second chapter was on law and legal procedure, which is one of the biggest chapter that accounts for almost 1/3 of the entire text. So, suppose if the text is having 200 pages, now in 200 pages, how many pages you think? Almost 60 pages. That would be on the law and legal procedure. Do you not understand that this was a major contribution in the field of ancient jurisprudence of our country 1500, 2000 years back? The answer is yes. He used technical legal vocabulary. You will wonder that did he use the word plaintiff? Did he use the word defendant? Did he use the word suit and countersuit? Did he use the word witness? Proved. That was the word. Now you find it in the law of evidence. And in those times, he had written about proved. Then he says, he also used the term convicted, the importance of evidence and different ways to give evidence, documentary evidence, and also he told about verdict. He also discussed about formal written plaint, and he talked about documents, necessity of documents for getting loan. So, you might find that this text was a very long text, because you have known that Manusmriti was also having lot many verses, but was it a even expanded version of Manusmriti? The answer was no. This was a concise version. This text was very dense. So, you will find that it is not that lengthy as was Manusmriti. It has only just 1000 verses. So, it was almost half, more than half of the Manusmriti. So, you will see that there were those words which were used in those times, which are now also used, but in the 1000 years period before now, because of the invasions from different other parts of the world, our own words somewhere got lost, but still at some places you will find that these words are still prevalent. Legal document, document. The document means the written thing. So, legal document was called Lekhya. Now, Lekhya was used for the first time by Yajnavalkya. He showed for the first time in the legal history how a legal document is to be executed and what elements like signature, that you might know now, that if you write a document, if you execute a document, in law we will say execution of the document. So, when you execute a document, importance of witness is there. He talked about the importance of witness, he talked about signature of the executor and the role of scribe. Scribes are who write, deed writer. So, when you go to the court, you will find deed writer also. So, he talked about the scribes also. So, he says that when all these things will be completed, then only document will be complete in law, in the eyes of law. So, Lekhya will be complete when all these important elements are present. And you might have heard about the whole class of scribes. Today we call them deed writers, but because those were the times, and then our society disintegrated and our society became decadent, and many of the things were decided on the basis of birth of a person. So, if a person was born from that scribe class of people, then they would become kayastha. So, you see that these are the different phases of our society, but what I am telling you that the role of deed writer, that was emphasized in those times also. And you might also wonder that now we talk about the importance of yoga and International Day of Yoga, and what is the importance of yoga in our life. And you know what? Yajnavalkya was a great yogi. He had mastered the art of yoga, and therefore what he said, that by yoga only you can perceive the self, and perceiving the self is the highest dharma, and the second highest dharma is dan. So, you have to share whatever you have earned, you have to give it, you have to donate it, that is called dan. So, importance of dan and importance of yoga, both are important. You control your senses and then you do whatever you want to do, and then once you earn wealth and once you have acquired property and fame, then you should also donate it. So, that is called dan. He talks about non-payment of debts, and that may be the subject of litigation. If you can understand that if someone will take a debt and that person will not repay you, will not that be forming a dispute? So, in those times also this thing happened. People took loans, but they did not want to repay it. That was the subject matter of litigation. And then the rules about inheritance and partition of estate, those rules were also incorporated in the Dharma Shastra. So, you can now understand that how many rules were there, and on different aspects, and those were in 1500 years back. So, this is very important, and therefore, we should try to understand the other things what he wrote. He said that the sources of dharma are 6. What are those 6 things? First is Ved, then is Puran, third is logic, fourth is hermeneutics, fifth is legal treatises, and the 6th are the supplements to these great literature. And further he says that you can also get help from 20 promulgators of legal treatises. So, if you read Yajnavalkya's Dharma Shastra, you will find 20 names who had commented upon some of the rules which must be there in the society. And he gives those names. The first name was of Manu, then was of Vishnu, Yam, Angiras, Vashisht, Daksh, Samvarth, Astat, Tatap, Parashar, Apastamb, Ushans, Vyas, Katyayan, Brihaspati, Gautam, Shankh, Likhit, Harit, Atri, and Yajnavalkya himself. 20 promulgators of legal treatises. So, he says that you should not worry that if you do not find some rule in the Vedas, you can look in Puranas. If you do not find some rule in Puranas, you will go to logic, and likewise 20 other names were given. Then he says that 4 persons, if there are 4 persons who know the Vedas and Dharma, they constitute a legal assembly. You might have heard about the bench system in today's times. In the court also the bench system is there, single judge bench, division bench, full bench, constitution bench, and so on. Likewise, what he says, that if 4 persons who know the Vedas and Dharma, they constitute a legal assembly, or just an expert of triple Vedas. If a person knows 3 Vedas, then he can be a single judge bench and he can be giving help in the form of some opinion in law. Whatever that assembly declares, or if a person who is knowing 3 Vedas, that single individual, that declaration will become dharma. So, that will be the right thing. So, when such situations occur that way. So, that was the judgment. Today we know the importance of judgment. In those times he did not say that this would be the judgment of the court, but what he said that whatever will be the declaration of this legal assembly or even the one person court, that will be important, and that is called dharma. Further he says that the root of dharma was what? The practice of good people, and therefore whatever desires which are springing from right intention, that will be the root of dharma. So, you see that he was talking about dharma and what is the importance of dharma, because dharma was the rightful conduct. Rightful conduct, if there will be rightful conduct, there will be peace and security in the society. There will be no chaos in the society. If everyone will conduct in a rightful manner, there will be peace, and without peace you cannot prosper. What further he says that what sort of dharma a person should follow, that is also written in Dharma Shastra. And further, which is another thing that he said is very important, and that is relating to the practice of the people. Unlike Manusmriti, where Manu said that the king has great power to resolve the disputes, king has the power, sovereign was given the divine status, but Yajnavalkya was disagreeing with that. He said that one should not perform even an act which is prescribed by Veda if that is repulsive to the world. World means the people who are living. So, if that is repulsive, if people do not like the practice or whatever rule is given in Veda, that will not be dharma. So, that was important. That was a kind of historical school. You remember historical school, where historical school was laying emphasis upon the practices of the people, but then historical school only focused on that aspect. Here was the person who had combined the role of the king as well as the Vedas, and then he said that if it is repulsive, means if it is repugnant, totally repugnant to the practices of the people, then what will happen? The Vedas should not be observed. Next we will see the position of king or sovereign in disputes. You might wonder that in those times there might have been less population and there might have been very less disputes, but would those disputes be left on themselves? There would be no resolution techniques? The answer was that there were rules which were laid down to resolve the disputes, and the highest power which was given to resolve the dispute, that was given to the kings or the sovereigns. The king or the sovereign should try lawsuits accompanied by Brahmans in conformity with treatises on dharma and free from anger and greed. Now, you might wonder, why did he say about Brahmans? Why did not he say that other people, other ashram, other varnas, they could also be there? Because that was the time of inequality, and he had said that who is a Brahman? Brahman is not who just takes birth in a Brahman family, but he said that Brahman is that person who knows the Vedas, who knows the Brahmans, who knows the Upanishads. If that is not within the mind and he doesn't or she doesn't understand these things, then no such person can be called Brahman. So, what he says that king, when he is trying lawsuits, then he must be accompanied by the learned Brahmins in conformity with treatises on dharma and free from anger. A judge should not be having anger. A judge should not have greed. If the judgment is written out of anger, the judgment will not be a good judgment. So, he gave this rule of conduct for the judges also, that without anger, without greed, any kind of judgment can be given. Then the position of king was that the king could appoint as court officers those individuals who possessed erudition and he was a scholar of Vedas. He must belong to distinguished families. He must speak the truth and treat both friends and foes alike. If someone will treat friends in a very different manner in the court, that will not be allowed. You have to treat your friends and foe on an equal basis when you are in the position to resolve the dispute. So, what he said, that when there is a pressure of work, when king is having pressure of work, because you might assume that king is having a lot of things to do, in such case what he can do? He can assign a Brahman who is learned in every facet of dharma along with other assessors. So, the kings of those times, sovereigns, officials, they were also authorized to resolve the disputes, because king not always was having time to resolve the disputes. So, delegation of powers, delegation, you might have learnt about delegation of powers, delegated legislation. So, here also there was this possibility, king could delegate his powers to some of his officers and they could adjudicate the suits, the lawsuits. And if a dispute came from associations, guilds and families, then also those disputes could be resolved. So, we might have seen that there were different types of disputes and the king, the sovereign officials, the people who were authorized by the king, they had the power to resolve those disputes. People who were living in the countryside, when they stray from the dharma which was specific to them, then what was the power of the king? The power of the king was to discipline them and set them on the right path. If a family does not perform the duties, then it was the power of the king to discipline the family and make them and to put them on the right path. Likewise, the guilds, the companies, the associations, they also, if they did not observe the right path, then what would happen? That the king could discipline them and set them on the right path. So, you have seen in this slide that the position of king was different. They were given a very high status. They had the power, ultimate power to decide a dispute, but the king could not do all those things himself or herself. Therefore, they had devised a system by which they could appoint the other persons who could resolve the disputes. Now, was the king possessing absolute powers? Did the king enjoy absolute supremacy? There was none above him? The answer was no. When Yajnavalkya said that even the kings had to abide by the dharmas. Now, king might have said, if you abide by the dharma, then are you a king? Yajnavalkya said, even the kings had to abide by it. So, what was the duty, what was the dharma of the sovereign. The first thing what he said was, there was no greater dharma for a king than giving the wealth won in the battle to Brahmins and granting safety to his subjects. Now, safety of the subjects is very important. That is the most important dharma of a king. We may not agree now in our times, this jurisprudence is not there, that king will have to apportion some of the booty to the Brahmins. This is not the jurisprudence for modern times. But this part, that the safety of his subjects, that was the highest dharma for the king, that is still relevant. If any government that comes to power, and if that government forgets the safety of his people, then what will be the result of that government? What will be the fate of that government? So, you can see that the jurisprudence on this aspect, that was also laid down in those times. Further, when someone becomes a king, can he kill anyone he likes? Can he inflict harm to anyone he or she likes because he is so powerful? The answer is no. He says he should not kill a person who declares, I am yours. When someone says, I am yours, it means that the person has surrendered. Thereafter, there is no need to kill that person. Who is effeminate, who is not manly, who is effeminate, in such case also the king should not kill the person. Who is without a weapon, when someone is not having weapon, then will you kill that person? He makes the rule. He says that those persons without weapon, those persons who are defenseless, they should not be killed. Or who is engaged in battle with someone else, he is not engaging in battle with you, and then you will kill them. The rule was, no, you should not kill them. So, he tried to make rules even regarding the battlefield. He was not content with the peace times. He said that when the war time comes, when there will be war or conflict, then also the king has to, because kings are going and they take the lead role in protecting the safety and the territorial integrity of the nation, then what will happen? Can he engage in any type of war? The answer was no. He has to give these important things a very important consideration. A man who flees away from the war, he is not coming and he is not using any weapon, but he is fleeing away from the war field. The king was not to inflict any harm. King must not have inflicted any harm, because that was the dharma for the king. That was important rule for the king. A person who is just a spectator of the battle, you suppose if some press people, they want to cover the battle, will they be killed? Because they are just spectators. They just want to witness how the battle is being fought. Will those people be killed? The answer is no. Yajnavalkya said that people who are spectator of the battle, they will also not be killed. So, this was the kind of ancient jurisprudence, that in ancient India also there were rules not only for the peace time, not only for the families, not only for the guilds and associations, traders, but there were also rules about the king, how the king could conduct the warfare. And further he says, because the state has also to run, how the state will be run, because treasury is important, and the treasury will not be having money if no one will give the tax. So, what he said, that king can take 1/6 of the merits by providing protection justly, because providing protection justly is greater than all gifts. If you are protected, if the normal citizens of a country feel protected, that no one will hurt that citizen of the country. Now, in in lieu of that, the citizen can give tax. So, whatever the citizen will earn, he or she can give tax to the state. Yajnavalkya prescribed maximum 1/6 of the total earning that should be given to the state, but that was the maximum. You might imagine that today the tax is also levied. Today we are levied around 30% tax, but in those times 1000 years back 16%, 1/6 might also be, because when you have to give tax you feel that it is a very heavy burden on us. But you imagine that if you will not give tax, then the government will not be able to protect you. Government needs weapons, government needs modern ammunitions. How those weapons and ammunitions will come? And therefore, this taxation, and in our country we have also to build infrastructure. To build infrastructure, great infrastructure, to progress, to develop, we need the taxation system, strong, robust taxation system. So, in those times also Yajnavalkya prescribed about the taxation system. But at the same time he says that when the king tries to increase his treasury by taking unjustly from his people, then what will happen? Then he gives a caution. He says that such king will not live long, and he will be bereft of his sovereignty. He gives a kind of reprimand, saying that that king who takes away unjustly from his subjects, that king will not remain for long, and he will lose his sovereignty. And he will not only lose the sovereignty, but he will perish along with his relatives. You know, that was a great thing that he said, that king should also, don't think that you are the supreme power, but you must abide by the rightful conduct. You must see that your people are safe, not only safe, but when they earn, you should not take their earnings unjustly. Now we will see that the kingdom, how the kingdom should be run, how the state should be run, and what was the rule about it. Yajnavalkya said that a kingdom has 7 limbs, and what are those limbs? As we all know that limb is very important in a human body. The importance of limb, you see, the hand, without hand what can happen? Without legs what will happen? And likewise the limbs of state, he said there are 7 limbs of the state. One is lord, other is minister, other is countryside, next is fort, treasury, army and allies. These are the 7 limbs of the state. And then he says that who created the dharma? He says dharma was created by Brahmans in the shape of punishment. Now I may disagree with this. We can't say that dharma or the rules are made by Brahmans. The situation, the times have changed. We cannot give one class of people power to make the rules. But then we have now the competent authorities. We have the legislature, we have the parliament, and these competent authorities are given the power to make rules. So the rules will be now created not by Brahmans, but by the competent authorities or the bodies. And the king must inflict punishment. Now that is relevant even today. Every law which is made, that law somewhere or the other contains some kind of punishment. So what Yajnavalkya said, that when dharma is wielded according to the dictates of authoritative texts, then what will happen? That it will be a very good situation. But when unjust punishment will be given, then that will be destructive of the world, heaven and fame also. Therefore, inflicting punishment must be proper, and if punishment is properly given, then you know what, good things will be there. Heaven, you will go to heaven, you will get fame, and the king will be victorious. So, punishment is very important, and therefore, you must understand that what was the importance of the punishment in those times. Now, we will also look at the rules regarding marriage. Yajnavalkya was the person who said that marriage was prohibited amongst Sapind and amongst the prohibited relationship. You may now know that our Hindu Marriage Act of 1955 that provides for such possibilities, that marriage can be declared void because the marriage was performed within the Sapinds. If a marriage is taking place within the prohibited relationship, then also marriage is declared null and void. So, in those times, thousands of years back, Yajnavalkya had given this rule in Dharmashastra that there should be prohibition on such kind of marriages. He said that marriages are of different types. One is Brahma, another is Asur, third is Gandharv, fourth is Rakshas and Pisach. You remember Manusmriti had written about 8 types of marriage, and then he says no, now the times have changed, there are only 5 types of marriages. Then he also says what are the grounds of abandoning a married woman or divorcing, what we say now divorcing. What were the grounds of divorcing a married woman? He says that there may be some grounds like violation of chastity, killing the fetus, that was great. Killing fetus is now punishable. So, in those times, but killing fetus, that was a ground for divorce. Commission of grievous sin, taking liquor, that was also not allowed. Ailing, you are always ailing. Deceitful, foul mouthed, hating husband. Now, this last one is little bit different. The last one is hating husband. So, that is problematic for today, because husbands are normally hated by the wives, but he says that if that is converting into a situation which may be very difficult, in that case there can be a ground of divorce. So, what he says that when a husband, you might worry, you might wonder that when a husband is tainted with a grievous sin, then can a woman divorce that husband? The answer is very cautionary. Yajnavalkya says that married woman should wait for him until he is purified. If he is not purified, then she can give divorce, but otherwise women, they have to wait. Now, that was little bit discriminatory for girls, it was a ground of a divorce, but for boys the girl had to wait for some time. Further, he says that a divorced woman must be maintained. Maintenance of wife is important, but even a divorced wife must be given maintenance, otherwise the husband will incur a great sin. And what he says that if there will be harmony between husband and wife, then what will happen? That the family prospers. So, you see that even relating to the marriage, he had laid down certain rules, because marriage was considered to be a social institution. That was the sign of a progressive society. That was the sign of a society where there will be peace, because the people, they observe, they have the faith in this institution, the institution of marriage, and therefore, he made rules regarding marriage. So, in those times, Yajnavalkya had said that Brahma created Brahmans, and therefore, you have to please the Brahmans. And what he said, Brahmans must devote themselves to learning and Vedic recitation. because without learning the Vedas, without reciting the Vedas, they will not be entitled to become Brahmans. And what he says, that a person is worthy recipient of gift not simply by reason of knowledge or even ascetic toil, but when a person possesses proper conduct as well as those two, then only he is a true and worthy recipient of gift. So, you might have seen that what Yajnavalkya said, that gift has to be given to the Brahmans, but you know what, who is the worthy recipient of gift? Like today's law is that gift can be given to the recipient, but in those times also he said that gift has to be given to Brahmans, but then who is a worthy recipient? So, here he said that not only by reason of knowledge, knowledge is required, but apart from knowledge, what he said, that he must have proper conduct. So, if a Brahman is not having proper conduct and only he is knowing the Vedas, that will not be making himself worthy of a gift. So, what he says, that a person who does not possess knowledge and ascetic toil, he himself should not accept any donation, but if he wants to take donation, then the person who gives the donation, he should stop himself, he should not give donation. And further he says that should he accept, he leads both the giver and the himself to the nether world. It is like corruption. So, corruption, who gives money in bribe, that person is also who has committed a wrong, who has committed a sin. So, likewise here also the person who accepts donation, but he does not have good conduct, that person will not also be a worthy recipient of gift. So, friends, this is the time that we must know that the inequality was prevalent in those times, but today's times are different. So, we may not agree with today's times that how can one class of person they will be treated differently. So, this is how we see that Yajnavalkya had written about the role of the Brahmans. Next, what we will see, what was the jurisprudence, what was the basic lessons that he told us about the evidence, how the court will appreciate the evidence. He was the first author to deal with ordeals explicitly. He says that to establish innocence, ordeals are prescribed, and in case of serious accusations, ordeals were must. And what he says, that the technical term for ordeal was dibya. You become dibya only when you undergo through ordeals. And he described in detail various types of ordeals like balance, fire, water ordeal, poison ordeal and holy water ordeal. So, this was the kind of technique, this was the technique of dispute resolution, techniques of giving punishment, but these ordeals someone had to undergo. But he gave some different space for women and for children, for elderly, for afflicted, for crippled, for sick people, and he said that for these kind of people there will be no ordeal of poison, there will be no ordeal of fire, but there will be ordeal which will be balance ordeal. So, in those times he knew that there should be some affirmative place, affirmative action on the part of the lawmakers, and therefore he said that different type of ordeal. What was the next? For persons, but this was discriminatory, we cannot accept in today's time. He said that for a non-Shudra, fire and water ordeal that were prescribed, but for a Shudra, even poison ordeal, that was the rule. But these rules, if those would be prevalent today, these rules will not be acceptable, because those were based upon inequality. Today is the time when our constitution says that there will be a society where everyone will be treated equally, the right of equality, fundamental right to equality. So, no one should be treated differently, and therefore, there will be no different punishment on the basis of varna. everyone is equal. Now, we will move on to some of the rules relating to partition of inheritance. He says that if the father carries out partition, he may partition shares among his sons as he pleases. So, father was given absolute right, but he says he may either present it to the eldest son, the preeminent share, or make all his sons have equal shares. So, father, when he is living, when he wants to distribute his property, then he has such kind of powers, so that there will be smooth transition of the estate, there will be no dispute. So, he gave the rule regarding that. And when the parents have passed away, he says that the sons should divide the assets and the debts equally. It is not that debts will not be divided equally. Assets are also to be divided equally and debts are also to be divided equally. And further he says that anything else that someone has acquired without using up the paternal property as also a gift from a friend or even a wedding present, that do not belong to heirs. So, paternal property, the use of paternal property is must. If something is acquired after the use of paternal property, then that wealth will be inherited by the succeeding generations. And he also had thought about a possibility. What he says, when someone denies that a partition has taken place, then the proof of partition will be based upon the witness of maternal and paternal witnesses and relatives, and the documents, as well as on the receipt of property and on separately held houses and fields. All these will be important to know that whether a partition took place or not. Today also you might have seen partition taking place in family. So, you have to understand that partition rules were framed in those times. So, what we now understand, that Yajnavalkya's contribution to jurisprudence, the ancient Bhartiya jurisprudence, was prominent, and in those times he had tried to give rules relating to marriage, relating to the power of the king, relating to the resolution of disputes, relating to inheritance and succession. So, we have seen that if these basic things are regulated by the rule giver, then what will happen? The society will be a civilized society, and therefore, it is the contribution of ancient Bhartiya jurisprudence which is very important to be understood, because if we forget our own jurisprudence, because even the kings were duty bound, every member of the family was duty bound, and so the rules relating to different members of trade associations, guilds, and therefore even the taxation system. So, we have to understand that we have the long tradition of our own jurisprudence, but at the same time we must not forget that we have the constitution, which is the highest law of the country. We should not forget that if the Yajnavalkya's Dharmashastra rules, they are in conflict with the constitution, then we must not forget that the rule which is there in the constitution, the rule which is there in the laws which are passed by our own parliament or the state legislature, that will prevail over Yajnavalkya's Dharmashastra rules. So, that has to be the lesson now, that we have to also give lot of importance to the current laws and the constitution of our country. I hope that you may have understood the basics of Yajnavalkya's Dharmashastra and what was the contribution of Yajnavalkya to ancient Bhartiya jurisprudence. I hope that you must have enjoyed this lecture, and with this I thank you very much for giving your kind attention.
Understanding oneself, understanding others, understanding society at large, understanding the nature, these are all driven by basic human curiosity. We would all love to understand why things happen, what happens, what is the final outcome, why certain things fail. These are all exercises that we perform in various domains of knowledge. Therefore, knowledge in various domains, you would realize they are actually social artifacts. They have to be rooted into historical perspective, they have to be culturally salient, and there would be socio-political reasons behind this. Whether you talk with respect to engineering sciences, whether you talk with respect to physical sciences, biological sciences, social sciences, that's the reason why humanities and social sciences should be understood by all of us. The knowledge that is segregated, that is divided with respect to areas, specializations, all of them needs to be understood in its context. And what provides the context? It is the social reality. How do you correlate knowledge in a given domain with the cultural reality, with the social reality, with the socio-political compulsions? Okay, how do you understand the law of nature, okay, in its totality? And for doing that, you require the understanding of humanities and social sciences. Say for instance, if you are trying to understand the effect of a particular bacteria, a virus, any microbe, how it affects behavior, how it affects the organism, human being, you start looking at it from a pure biological point of view. If you are trying to look at a particular type of a wavelength, say for example, you are emphasizing on the understanding of the effect of radiation on human life, you are looking at things from a physical point of view. You are looking at the corresponding changes inside the body, you are looking at the physiological side of the understanding of the information. You are trying to understand why, despite knowing the risk that is inbuilt in the process, why still human beings engage into it. You are looking at it from a pure behavioral point of view. Why society at large admire things which has full of risk. You are trying to understand things from a pure sociological point of view. Why people use particular set of words to explain those experiences. You are trying to understand things from the linguistic point of view. So, there are a whole lot of things, and then finally you try to combine all of them to say that what are the guiding principles in life. Then you say you are looking at life, you are looking at humanity from a pure philosophical point of view, and this is what social sciences courses provide you. They provide the context to you in which you would be finally positioning the understanding of the knowledge in any given domain. It could be engineering, it could be sciences, it could be medical sciences, it could be social sciences stuff, it could be humanities stuff. So, contextualizing the knowledge is what humanities social science courses help you obtain.